Good evening, ma'am.
Yes.
Thank you very much, madam, for the nice lecture on the topic of plant varieties, its protection and effectiveness in India. Uh, we have a few queries in the chat box. I will read them out for you, ma'am.
Yeah, please.
Mr. Samrat Bandhopadhyay asks that when there is patent in the current regime for patent of microorganism, then in future, is it possible for patents in seeds and plant breeders' rights? Whether patent is possible in future with respect to
Okay.
plant varieties.
As such, US is having the plant patent protection. If we are just taking the idea from other, just that's why I'm just mentioning. They have the patent for the asexually reproduced plant, not the regular plant. Even they discard the tuber, tuber propagated, like our how we get used to get the potato, tuber propagated. So tuber propagated plant also they never consider. So it's just the asexually runner. You know that just to take the stem and you can have the rose. So in this manner, they are covering under the plant patent. That is the US understanding. Now, in case of EU understanding or UK understanding, what is the thing? There are several cases. Now, I have seen in other country also, they go by the policy even. Sometimes they show the aggressiveness, sometimes they just came, just in a back foot they used to play. So the thing is like that, in those cases, what I figure it out, that plant as a whole or part or essential biological process is not coming under the patent for EU, for UK even. Now, human intervention, the laboratory intervention. So, transgenic plant. So, I have implanted something there. So there is a tomato case, broccoli case, so less water content tomato or enhanced vitamin E broccoli. So this type of some cases where somehow the ECJ accepted that laboratory invention, that particular process can come under the patent. Okay, so product by that particular process is coming under the patent. Now coming to the Indian stand, India is very clear. We have section 3J. So non-patentable subject matter is coming into our way. Now, Nuzivudu case, in a same manner of the tomato or broccoli of Europe, they raise that particular question. So it is not coming under essential biological process. So there is a laboratory intervention. They have inserted that particular BT gene, so they can. Yes or no, it is sub judice still now. We don't have the thing. But primarily the single bench of the Delhi High Court told no, it is coming under the plant variety. So we have a plant variety protection already, though we have seen the PepsiCo case that infringement can come to the farmers also, because as per that section 64 it can be, but as such not possible. But if India is going to interpret in a same manner like a biotechnology board of Europe, that those laboratory intervention under laboratory method, not at all it is giving the product, then maybe at the very moment we don't have any case.
There is a continuation to the question. How far this plant varieties are successful in foreign countries vis-a-vis success and awareness in Indian perspective?
Okay, the thing is like that, see, if we see the history of the plant variety protection, other country and India is a very newcomer in that sense. 2001 only we have started the journey. So we have seen they're also apprehensive. They were not in the food products. They thought about the ornamental plants, some in essence plant, which is not really coming into the way of the food security. If you trace back the history of the plant variety. So this is very evident. They are also apprehensive to go for the intellectual property protection for the crops, for all those things. But gradually, because of the globalization, because of the investment theory, all these things, we know that they're also having. So UPOV is already there, where they are protecting the breeders' rights, and Europe US, Australia, Canada, they're corporation-based agriculture. So Monsanto, if you visit the website of the Monsanto, their aim is dominate the agriculture of the whole world. So that's the thing. So they're, of course, they're investing, they're thinking about because of the population growth, yield is necessary, this enhancement is needed, that enhancement is needed, they're putting the money, so they want to recover that particular money. So again, there is somehow public interest clash, and this can be. So this is the situation. But yes, I mean, as such, we can see the European Union, they are not very much aggressively working on the monopolistic, but US, yes, they have they are part of UPOV. They have a Plant Patent Act 1930. They protect the plant under PVPA. There is another sui generis mechanism is there. There is a, they apply the utility patent, the younger brother of patent, means the lower threshold of novelty and lower threshold of the no inventive step. In this manner, they are covering 5 way to protect the thing. So somehow US is very much into it, but EU in a balanced way. So some cases, and I have seen that it totally based on the, maybe the policy wise or market demand, sometimes they are pushing the thing, and sometimes they're literally laid back in situation. So this is the thing. Now, in case of the India, as I told, we are not corporation-based agriculture thing, and our farmers, so farmers' rights is there. Some definition, you got that from my tone, I think, where we have that problem. So we have a problem with some definition, and we have some problem with the procedural thing. I think we need to work on, because claiming the compensation or claiming the benefit sharing, it's not pretty easy by the farmers. If any NGO is dedicatedly working there, or any government facilitate all those things, it's not really easy for them. So success, I know specifically Odisha is really doing good for the plant variety protection. Uh, in case of, that our biological resources, even some state biodiversity board is very doing very good, like Andhra Pradesh, I know, Gujarat, then the Uttarakhand, Maharashtra, they're doing really good in comparison to other state biodiversity board. In a same manner, some state are doing good, but how far it could be effective from the farmer's point of view, or very rigid intellectual property, how much is going to give us the return for the our typical agricultural practice, it's still questionable. I'm sorry for my a very conservative view. Maybe good lot of people differ with me, but this is my own opinion. I mean, I'm sorry for that. I mean, till now I'm not in the thinking that we can really do very good as per our agricultural practice. This is my conservative view. Yes.
There is another question from Miss Irene Pereira. When member countries send seeds to the seed bank, is the patent lost, or does it come under public interest? Probably there is some clarity that is required regarding seed banks. There was another comment also from the same person about seed banks. Can you
Okay.
please
Okay.
elaborate about seed
Yes.
banks, madam?
There is a already we have a Cartagena protocol for the LMO GMO trans-border thing for the public safety, health and safety. It's prohibited. 2 member state need a very, they need to give the, I mean, need to take the permission, then other state need to give the consent, then only any genetically modified organism or LMO, living modified organism, can. So as per the Cartagena protocol, we are part of it, because with the CBD we are having this Cartagena protocol also. So that is already as such barred. It's not really easy to do that. It's a part of a health and safety. And contamination of the land races of the local variety is also the question. So in this manner, it is as such very strictly prohibited. So there is a need of permission, then the consent, then only can go that. But yes, and under the ITPGR FRA, there is a gene bank. So I know that particular good lot of rice variety from India, they have collected. This is the UN, under the United Nations. So they have collected all the rice varieties just to have the store it in the bank. Now it's a good lot of question came into the mind. I have heard from the agricultural scientist and very, I mean, not as such the layman farmers, but the farmers who having that sort of knowledge, they were not happy with it because they don't know. So there is certain gaps of that. But our national gene bank across the country, for the conservation purpose also, so anyone can revive any variety or any variety is not available, so it's a repository in this manner they are actually. But yes, somehow through the UN controlled or UN monitored, this particular thing is, the clarity is missing for this. But as such, you are not allowed to take the seedling or seeds from one country to other. It's not basically allowed. So if you are doing that particular thing without the knowledge of the authority, so basically it is considered illegal. So the thing is like that, under any formal way or official way, the UN Gene Bank under ITPGR FRA, they used to do, but proper guideline and what exactly how they're going to help, they're also stating in a same manner like our national gene bank. But how much any country can get help from there, I mean, some theoretical thing is there, but practical implementation of that or a clear guidance or clear guideline is, yes, still now missing.
Another question from Mr. Panir Selvam.
Yes.
Madam, can you give certain recent cases regarding plant varieties?
Okay, so we have a, I mean, age-old case of the Nuzivudu case, and Nuzivudu case is still now pending. So primarily it came, and we have denoted it's a plant variety case. I mean, not the patent case. They ask for the patent. That is the thing. And then it is sub judice still now. That's why I'm telling that laboratory intervention can be considered under patent, yes or no. We have to wait to get the answer from the court. But till now, the case up to the Delhi High Court case, it is clear. Justice Ravindra Bhatt cleared that no, it's a plant variety case. It's a plant variety coming under the PVP FRA. And as per Section 3J, whole or part of the plant, we are not giving the patent. That is the thing, Nuzuvidu case. It's a famous one. Now, apart from that, recently we have a PepsiCo case where that, I mean, they just have the sack of potato and they start cultivating it, and PepsiCo is having that variety protected, they claimed, and they sue again. I mean, there is a negotiation happened. Primarily it's a under Section 64, it's an infringement case. Then the negotiation happened there. Those Gujarat based farmers are going to cultivate those potato varieties from where, from those potato they are producing the Lay's potato chips. Then some negotiation happened, whatever maybe the infringement damages, that is somehow. Now recent development is this particular potato variety got invalidate, I mean, plant variety authority invalidated those varieties based on the public interest. Somehow throughout act as such, there is no mention, but it's a very recent development based on the I mean, public interest or public need, those particular because I have just told which cannot be registered or which can be registered. So nothing mentioned like that. But yes, this case is, I mean, somehow the PepsiCo lost the validity of that plant variety because of the public interest. We have a
Yeah.
very less case on the plant variety. I mean, anyhow, geographical indication, plant variety, and section 6 of biological resources or access and benefit sharing mechanism, these are the things are very non-conventional IP and most neglected part, because we never considered like trademark, patent, or copyright.
Yes, ma'am. That brings us to the next question, ma'am. So, how far the plant variety protection and geographical indication are related?
I told
Yes,
geographical
ma'am.
indication is gift of nature. A specific geographical factor is giving that particular plant. So the criteria is very clear. So this particular unique agricultural product you are getting because of the soil, because of the climate. It is nothing crafted because of the humidity, all these things. So we can cultivate, okay, something anywhere. So maybe himshagor mango I can cultivate in Rajasthan, but I cannot get that sweetness or that particular quality or uniqueness what I used to get in West Bengal. Or the shahi lychee, or Kerala red banana, not possible. So in this manner, geographical indication is that. Now, in case of variety, I just explained that it's a need base also. So our farmers or breeders, they come up with the new variety. They come up with the new variety as per need also. We need flood resistant variety. We need drought resistance variety, pest resistance variety. So it's a crafted one. So the natural Shahi lychee, what got by the Bihar, Muzaffarpur is cultivating that particular lychee. So if I come up with any plant variety from the lychee, yes, I can go for the plant variety protection. That variety again, I cannot call it for a geographical indication, because it is not because of the natural gift. It is crafted one. Just distinguish that particular thing. I think there is another question.
Yes,
Plant
ma'am.
varieties and plant categories are the same, and protection available under the geographical indication for both. I have just clarified. Plant variety is not coming under the geographical indication and agricultural product. Geographical indication is a having a serious sanctity. So Darjeeling tea, see, throughout India, we have several tea. Kangra Valley is having tea, Nilgiri is having tea, Munnar is having tea, Kurnoor is having tea, and Darjeeling is also having tea, Assam is also having tea. Why every possible tea is not same? Because Darjeeling, that particular iron mixed soil, the misty weather, that particular geographic location, geographical factor is giving that unique tea, which is very much flavor is so high, liquor is so low. If you want to have a strong tea, don't take Darjeeling tea, take Assam tea. So that's the difference. It's a high scent, aromatic tea, actually, Darjeeling tea. Flavor is high, not the liquor. Assam tea, on the other hand, is having a very strong liquor. So that is the geographical location is having that uniqueness in the product. Now, from that product, now I am taking the Assam tea, and I want the ginger flavor Assam tea, and I am literally hybriding that. You know the hybrid variety, correct? Hybriding that, like we get rose red and white, and then we can get a pink, something like that. So I'm breeding with that, then I'm getting another variety. So it's a crafted one, not a natural gift from the geography. So geographical location, when you giving you the natural gift because of that particular geographical character, that is the sanctity of the agricultural product of geographical indication. And plant varieties always crafted, you figure out as per your need, maybe hybrid, maybe natural selection. So you have figured it out. So the criteria is totally different. The rights are totally different. Geographical indication is a community right. Plant variety, one individual can have the right. That is why you can give the license, you can give the assignment. For geographical indication, you cannot give the license. You cannot give the assignment. Geographical indication only authorize the user to sell it, market genuine geographical indication product. That's it. So geographical indication, maybe the group of farmers is the producer. They are the community, fine. But it's a gift of nature. It's not crafted one. And we are nurturing it. Human factor is here. Just we are nurturing it. We are a good custodian. That's it.
We have one more question that has come forward. Probably it was mentioned in your lecture by Mr. Ritvik. What are the main reasons why India is still not a member of UPOV Convention?
As I mentioned, that UPOV is actually taking care of the breeders' right. So there is no farmers mention. So when 2001 we had so there are several people like Bandana Shiva, Suman Sahai. There are so many NGOs also. I'm not telling they're not correct. They're very much correct. As I told in a very starting point, our agricultural system is totally different. We can't replicate the model of European Union or US or Canada or Australia. So small farmer base, we are not corporation based agriculture. So UPO from their point of view, so they're actually looking after the corporation based agriculture. So somehow, but interestingly, good lot of provisions are really same in our Plant Variety Protection and Farmers' Rights Act. So, but we have the special emphasis also. We can't deny that truth also. So we are literally having the farmers' rights, specifically sow, resow, share. That's there. That is the uniqueness of our PVPFRA. So we don't, our farmers need not to fulfill all those criteria. Key application, then opposition, then all those things. That is not mandatory for the farmers. So the specific emphasis on the farmers, that is the uniqueness of our PVPFRA, and that is why we are not joining the UPOV. Though there are certain point we can still criticize, or certain questions we can put, that how much really the farmers' rights. Yeah, some question I have raised also those questions as a scholar, because we have to, academics, we have to raise the questions we raise the questions. Why? Because we are looking for the perfect one or proper one, or we're looking for the development. That is one. So those questions are also there, but on the contrary, this special emphasis for the farmers is also there. We can't deny that truth also. So it's a very much the thing. So we are not joining the UPOV because of that reason. 98 and 1991, and 1991 Act is much more rigid, and they totally stopped 1978 Act. Now only the 1991 Act is open for them. African countries are now crying literally because of the free trade agreement, because of the push, they are part of the UPOV. So they are not really happy with. So in this manner, we are not part of UPOV. We are fine. So that's my own opinion.
Thank you for sharing your considered opinion. Now I request our chair, Professor G. V. Reddy sir, to please continue the proceedings.
Yeah, I think that made a very interesting 1 hour of highly scholarly discourse from Dr. Gargi Chakrabarti. And as far as the clarification regarding the GIs and plant varieties protection, she has explained very well. So GIs can be kept in the private domain forever, but the plant varieties will come to an end. The protection will come to an end after 15 or 18 years of registration, depending on the nature, whether they are extant varieties or not. But GIs, if renewed, can be continued forever, like whether it is, we have seen champagne and many other things which are still going strong after 100 years. Anyway, that is one aspect, and Madam has explained very well about Nujividi seeds case, which is still pending. There are certain other interesting cases, of course, not from India, but other parts of the world, like Canada. We have, the Canadian Monsanto versus Miser's case, but that borders mostly the patent protection. The liability part, especially if they, are blown from one protected area to a neighbor's agricultural land, and if their growth there, and very unfortunately, the fellow was found liable, though no damages were paid, directed to be paid by him. Then, of course, we also have certain good developments in the state of Telangana. We have Telangana Sona, in fact, which is supposed to be a very good variety of rice, which can be consumed even by diabetic patients. And yes, and that is another important thing. And maybe one more aspect, I think, which probably deserves the attention of all the policymakers, not only policymakers, but also farmers and their organizations, is the gene fund. How the gene fund could be maintained properly under Section 45 of the Act. But I'm absolutely sure that what Dr. Gargi has explained is, in fact, very clear, crystal clear to everyone, not only from the legal background, but also from the other disciplines. So I once again thank Dr. Gargi personally on my behalf